costing of time based on anything that the way this goes. I also want to make it clear that I am happy to answer questions as we go along. I think that would make more sense given the topic and how things sort of fit together. I also would encourage questions. In my experience, number one, it makes it better in terms of the interaction. Of course, you have to listen to me drone on about the questions as well. But also, more importantly, it certainly is my experience that if one person has a question, a lot of other folks might have a question as well. So we're going to go ahead and get started. And again, I hope to hear feedback from you during and after the webinar. One other upfront thing I just want to mention is that I know we have all sorts of different types of employers participating in this webinar today. So I will do my best to differentiate when I'm talking about public versus private sector or counties versus cities, things like that, because there are some nuances that I think bear some discussion today. So we'll go ahead and get started. First thing up front I want to make clear to everybody is that all of the effective dates that we're going to talk about today are accurate as of today, but as I'm sure all of you are aware, the Affordable Care Act has been subject to some delays and some modifications date-wise, primarily to allow employers some more time to comply, and there might be more changes coming down the road. Again, I'll try to point those out where I think that might be happening. The things I will repeat today that I've said in other presentations is the Affordable Care Act is not going away. I don't think it's going away between now and 2016, and I would be surprised if it goes away even after the presidential election of 2016, regardless what might happen there. So it's time for us to comply and to try to figure out some perhaps regulatory changes that we can try to seek as employers. So one of the things I want to spend a couple minutes talking about is the individual mandate. I know most of you are on here, or maybe all of you are on here because you're employers and you want to hear about the employer mandate, but I think it's important to talk about the individual mandate so employers have an understanding of that. I have heard from many people, and this might make a lot of sense at some point, that it is time perhaps in 2015 or 16 to for employers to get out of the business of health insurance provision or providing health insurance and allow their employees to go to the marketplace. Again, I don't know, that might make sense on an individualized basis or a company-by-company basis, but I want you folks to have at least a little understanding of that individual mandate. I do want to point out that the picture on this slide is probably not representative of the country as a whole percentage-wise, because it looks like all of these people are smiling, and usually when you talk about the Affordable Care Act there are some frowns. So bottom line is every person who has a household income greater than 138% of the federal poverty level must either enroll in a health care plan that offers minimum essential coverage to themselves and any dependents, or pay a tax penalty. Now, that enrollment can be through the exchanges, it can be through other private insurance, or for many people, it will be through their employer. Keeping in mind, in Ohio, the 138% of household income has of the poverty level, has some meaning across the board, because as you folks probably will all recall, one of the other things that the Affordable Care Act was designed to do was to raise the income level for those who might qualify for Medicaid from 133% of federal poverty level to 138%. Ultimately, the U.S. Supreme Court decided that that mandate could not be applied to the states, and states could only opt in to do so. Ohio did opt in, but in some states where they didn't opt in, there are going to be people in that 133 to 138% category who have no individual mandate and probably have no means or fewer means to get insurance. But that shouldn't affect folks in Ohio for right now. what is required is a minimal essential coverage in these plans, and all of the plans on the exchanges offer minimum essential coverage. We will talk about this in more detail about what minimum essential coverage is, but essentially it does apply, for our purposes, know that it applies to those plans purchased on the exchange, those plans offered by the employer as well, whether or not that plan is self-funded or fully insured, a more traditional plan. The minimum essential coverage applies. So what happens to these individuals if they fail to comply with the individual mandate? They will have to pay a tax penalty. And again, that penalty was always designed to go into effect January 1st, 2014, and was not part of the delay that we saw in terms of the employer mandate that was enacted or proclaimed, I should say, by the executive order last year. The penalty is, as you can see from this slide, really going to escalate from 2014 and thereafter. So the penalty is the lesser of, and I know this is a little bit confusing, whatever is more between those flat dollar amounts that appear on your screen or the percentage of taxable income that appear on your screen. So whatever is more is going to be the penalty, but if that amount is less than the national average premium at the bronze level offered through the state marketplace or the federal marketplace if the state doesn't have their own, then the lesser of those two figures will be the penalty. So in 2014, the penalty is only, and I put that in quotes, but $95. So that's not as big of a deal, I wouldn't think, as it's going to be in 2015 or 16 and beyond. And of course, as I said, it could be $95 or 1% of taxable income. So you can see how these numbers can add up pretty quickly. Also, for dependents under the age of 18, the penalty is half the individual amount that's noted there on your slide. So if somebody has 3 children under the age of 18, then that's going to be ratchet up that penalty even more. Although you should also note that the total household penalty cannot exceed 3 times the individual penalty. So there is a cap on it. Now there are some exceptions, and I'm just going to list some of these out, some of which I'm not going to talk about each exception to the individual mandate, but just to point out a couple that are more prominent or more likely to occur. Individuals who would have to pay 8% or more of their household income for premiums are exempted from the individual mandate. Individuals whose income places them below the minimum threshold for filing a tax return are exempted from the individual mandate. And that has an economic and a practical component. The economic component being that they don't make as much money, so they're exempted. But the practical component is that the way that the federal government is going to be enforcing these rules is based on the tax returns, and there's going to be new tax returns or new questions on everybody's tax returns about seeking information about whether they actually have minimum essential coverage. And as employers, you are also going to have to file new forms with the IRS that will be due, if electronically filed, by March 31st of each year. Your first obligation to do that will be in 2015. Technically, that is actually was delayed, is the reporting requirements for the employer, which resulted in the employer mandate being delayed because that's how it's going to be policed. Individuals who have been eligible for Medicaid, who would have been eligible for Medicaid under the Affordable Care Act, but whose state chose not to expand the program will also be exempted. Now, that won't apply in Ohio because, as we know, Ohio has expanded that. Those with a bona fide religious objection to having insurance coverage will also be exempted. And just in a side note about that, there is a case that has been argued before the United States Supreme Court. It's Hobby Lobby Incorporated versus Sebelius. It is, and we expect a decision on this by the end of this month because the Supreme Court's term is up. That case will involves the challenge of Hobby Lobby as an employer who has a bona fide religious objection to offering certain contraceptives. Not all, but certain ones, and the U.S. Supreme Court's going to have to decide whether or not the Affordable Care Act allows for that kind of exemption and how far that exemption will go. So we'll have to stay tuned to that. The other thing is that individuals who have experienced a short coverage gap of less than 3 months also are not going to be penalized for under the individual mandate requirement. So what that means is that if somebody loses coverage for whatever reason, they have 3 months to go ahead and pick up new coverage, whether it's through COBRA, a new employer, or the exchanges. In addition, and related to that, if an individual is receiving premium assistance from the federal government, he or she has 3 months as a grace period to pay premiums. So that kind of meshes with the two. Also, there is discussion, and actually the law, it's not just discussion, but the Affordable Care Act also is intended to include large group insurance through marketplaces by 2017. So large employers are supposed to be allowed to buy through the marketplace by 2017. That's one of those things that we're just not sure if it's going to be delayed. Just a quick summary of what's available in very general terms. There are the minimum essential coverage can be through a bronze, silver, gold, or platinum plan. Not surprisingly, the bronze is going to pay less out of pocket, but also cost less. I'm sorry, you're going to have to pay more out of pocket. It pays for less as compared to some of the higher level plans. For purposes of comparisons, a lot of folks are focusing on silver plans. There's also, again, just as an aside, those individuals who are under 30 who are in good health are allowed to buy a catastrophic high deductible plan that's below the bronze level plan, but that's as far as it goes. Individuals who have a household income that does not exceed 400% of the federal poverty level will be those folks who are entitled to a tax subsidy if they purchase through an exchange, as long as the employer, if they're employed, does not offer coverage to them that's affordable and meets minimum essential requirements. And we'll talk about what that means. But as you can see, in 2014, the federal poverty level for a family of 4 is $95,400. So there will be certainly more than just a few individuals who go to the exchange who get that, who are eligible for that tax subsidy. And as I mentioned, individuals who will not get tax assistance if they have an adequate, affordable employer-sponsored plan available to them, whether or not they choose to enroll, or individuals who are eligible for Medicare or Medicaid. In 2014, the open enrollment is going to be November 15th to January 15th for those who are seeking coverage for the calendar year 2015. So that's what I wanted to sort of go over rather quickly in terms of the individual mandate. Now I want to talk about the employer mandate, which is why I'm sure most of you are on this webinar. So the employer mandate requires large employers to make available adequate, affordable coverage to all full-time employees and their eligible dependents. And we're going to break down that definition and talk about each of those components. If large employers fail to do that, then they will be hit with a tax penalty that, again, we'll talk about here in a minute. For those of you who are public sector entities, one of the questions that's come up, and unfortunately it's going to be resolved through litigation, or fortunately for us lawyers, is whether or not the federal government has the authority to impose a tax on public sector entities. clearly the U.S. Supreme Court found the Affordable Care Act, and specifically this component of it, to be lawful, to be constitutional, because it fell under the taxing authority of the federal government. That, like I said, is going to be one of many issues that could be litigated under the Affordable Care Act. Bona fide full-time employees are the only individuals to whom a large employer must offer health insurance. And those individuals are those who work 30 hours per week. However, in determining whether or not an employer meets the 50-employee threshold, you have to take into consideration those individuals who are full-time under the Affordable Care Act, which is 30 hours or more a week, and the full-time equivalents of part-time employees. And the way that you do that is for those individuals working less than 30 hours per week, you simply take the total number of hours those employees actually work per month, add them together, and divide by 120, and now you have your full-time equivalents that you add to 50. So it's possible that an employer has 30 real full-time employees, ends up with full-time equivalents of 20 more employees, and the Affordable Care Act will apply to them. Although, let me make this clear, those full-time equivalents are only considered for determining whether an employer is a large employer. It does not mean that those individuals working fewer than 30 hours a week are entitled to insurance through the employer. The other caveat, and this is something important for all employers, is to make it clear that in your policies or resolutions, if you're a public entity, or ordinances, is to make it obvious that the full-time definition under the Affordable Care Act only applies to the entitlement to health insurance. It doesn't have to apply to other benefits, such as the, let's say, vacation accrual. That, you know, if you can still have a 40-hour threshold for people who accrue vacation leave or things like that. So make sure that that's clear. So the definition, I said we'd break down that definition a little bit. And actually, I was a slide behind. Here's the information that I just discussed with you on the full-time equivalent employees. Move on to another component of the definition, which is those eligible dependents. So the statute defines eligible dependents include only actual biological or adopted children. It does not include spouses, stepchildren, or foster children, which means that you have no, as an employer, you have no obligation to offer insurance to those types of dependents, although of course you can do so. One of the reasons why this is really important is because I know a lot of employers are heading towards an approach that treats spouses differently than it treats employees. So some employers might say, I'm only hiring you, your spouse can get insurance some other place. Or I'm only hiring you and your spouse can only come on our plan if he or she cannot get benefits someplace else or with their employer. Or I'm only hiring you, your spouse can come on, but you got to pay a lot more money to add your spouse. So all of those methods that are currently or being used by employers to keep costs down by not covering as many people are still valid under the Affordable Care Act, or of course if you're contemplating imposing some of those restrictions. And unlike 2013 and before, when some employers said spouses can only be included if you are if you can't get insurance with your employer, now you can say spouses can't be included because you can go to the exchange if you so desire. It does. The definition of children under the Affordable Care Act requires you to cover any child up to the age of 26. Again, any adopted or biological child. That 26-year-old threshold applies regardless of the child's status or ability to get coverage. So that child could be married and employed with another employer, but your employee whose child is 25 years old and in that category that I just mentioned still has to be allowed to sign up for benefits under the employer's family plan according to the Affordable Care Act. Now, Ohio also extended that to 28, but the circumstances for children over 26 but under 28 in Ohio is different. In that situation, the person has to actually sign up for, not be able to sign up for health insurance with their employer. They can't be married. So there are some limitations that would apply to those 26, 27, and 28-year-olds. And you should make sure that your either third-party administrator or your insurer is making that clear in the summary plan of benefits so there's no misunderstanding about that. This is where I would say, does anybody have any questions? But since I see none, I'm going to keep moving on, and you're going to have to listen to me or get off of it.
We just got a question.
Okay, we just got a question.
Does legal guardianship count for only adopted children?
Question is, does legal guardianship count, or is it only adopted children that would entitle to these kind of benefits or coverage? And it is my understanding that legal guardianship does not count. It's only biological or adopted children that count in terms of employers' obligation to offer insurance. Again, you can do that over and above what the ACA says, but you don't have to. All right, so then I'm gonna shift gears, and again, if you have questions about things I've already asked, please chime in. It's perfectly fine, or I've already addressed, I should say. So now I'm going to talk about what I want to talk about is the penalties. What happens? Well, I'm sorry. Let me step back and mention one other thing. One of the delays, as you folks know, is the employer mandate. It was delayed to January 1st, 2015 from January 1st, 2014. However, the federal government also went further in its delay and said that only those employers with at least 100 or more bona fide and equivalent full-time employees have to comply in 2015. Those with 50 to 99 employees don't have to comply until 2016. So the other thing to keep in mind is that there is a safe harbor provision in the law. In 2015, a large employer will not be subject to the penalty as long as it offers at least 70% of its full-time employees, 30 hours a week or more, affordable, adequate health insurance coverage. So you can basically screw up on 30% of your employees in 2015 and not have to worry about a penalty. In 2016, that number is reduced from 70% to 95%. So you can only screw up on 5% of your employees in order to satisfy the safe harbor provisions under the law. And just so you know, before we start complaining that, man, that's a big difference between 30% to 5% in 1 year, which is true, the law originally said 5%. So the 30% was an exception that was created when the statute or this requirement of the statute was delayed. So what happens is if a large employer does not offer group health insurance to the applicable percentage in 15 or 16 to its full-time employees and their dependents as defined by the law, and at least one bona fide full-time employee enrolls in the marketplace plan and receives government assistance from that, based on that plan, then the employer will be subject to a penalty, which can be broken down on a monthly basis. So if the employer only screws up in 1 month out of the year, then the penalty is going to be a prorated amount. I want to make, before I talk about the actual penalty, I apologize, one other comment I want to make. The Affordable Care Act, it is perfectly legal for an employer to reduce the number of employees or reduce the number of hours an employee works to avoid coverage of the Act, with one exception, and that exception applies in 2015. Consistent or in conjunction with the delay, the rules that came out, the guidance that came out says that an employer cannot reduce its number of employees below 100 solely to avoid the application of the Affordable Care Act and the employer mandate in 2015. But in future years, you can reduce the number of employees you have or the number of full-time employees you have to get below 30 hours to ultimately get below 50 full-time employees, if that's feasible, just to avoid the application or the cost of complying with the Affordable Care Act. That's one of the criticisms, whether you agree with the law or not. One of the criticisms is that the 30-hour threshold is going to result in more part-time employees than full-time employment. I think we'll have to wait and see. So getting back to the actual penalty, the penalty that employers will face, and there's two different kinds. On the first penalty, what employers will face is that they would have to pay $2,000 times the number of full-time employees minus 30 on an annualized basis if the contingencies up on your screen occur. This is for an employer who just decides not to offer insurance at all. This is where we start getting to this question of employers may have of, should I get out of the health insurance business completely and just let employees go to the marketplace? Again, that's a perfectly lawful approach for employers to take. What would happen in that situation, or what I've heard employers discuss is that, or think about, sort of think out loud, is, all right, so we have 100 employees. If we pay a penalty of 70 employees, 70 of our employees times $2,000, we get a certain number. Now, let's say we also pay our employees several $1,000s to go to the exchange. Many of those employees, maybe not all, probably not all, but many of those employees will also get a tax subsidy. So is it feasible for us as a large employer to just pay the penalty, our employees something towards the cost of their health insurance? Again, you don't have to do that, but you can, and that's what some folks are considering. And then between what we're paying our employees and the subsidy most of them will get, perhaps we come out dollars ahead and perhaps they come out ahead as well. Again, time will only tell if that makes sense. It would not surprise me to see employers head in that direction, although some of that's going to depend on how the exchanges really work, which is why I'm encouraging clients to wait and see what happens in the next year or two, as opposed to jumping into it in 2015. And frankly, that's pretty much the approach I think most employers are taking at this point. One of the things to keep in mind is if you choose to go down that path, the amount of money that you give to employees is going to be considered regular income, and they're going to be taxed on it. So that means that a $1,000 payment you give to employees to subsidize their purchase of health insurance on the exchange is going to be worth less than $1,000 to them. And for those of you who are public employers, it's going to cost you more than $1,000 because you're going to have to make payments to make pension contributions and workers' comp, those kind of things that you pay on all of your payroll costs. So that's the first penalty. The second penalty, again, is going to have to be broken down a little bit as well. The second penalty applies if an employer offers insurance, and again, when I say employer, we're talking large employer. But a large employer offers insurance to all of its full-time employees, but that insurance isn't adequate or affordable under the ACA. What will happen is a large employer employer fails to offer adequate and affordable coverage, and at least one bona fide full-time employee enrolls in a marketplace plan and receives government assistance, then the employer is going to be subject to this penalty. Yes.
Bry's asking, do we have slides on the employer penalties? Will we be discussing that at all?
I do have a slide on the employer, and actually I'm happy to go to that slide right now. This is the slide that talks about the cost of the second penalty. I actually, and somewhat inadvertently, frankly, don't think I have a slide that actually discusses the first employer penalty. I do not, and I apologize for that. But let me go back and talk about the penalty, the first penalty. The first penalty that I just mentioned. If an employer fails to offer any insurance to all of its full-time employees, that penalty, as I mentioned, it's just a formula. It's $2,000 per year times the full number of full-time employees minus 30. So you can do the math with that. I went to law school so I could avoid math. So I'm not going to try to do that for you on any hypothetical example. But that's the penalty. That's the sum and substance of the penalty. The only other comment I need to make about that first penalty is if an employer only fails to do so on a monthly basis, then it's prorated to $167 per month times the number of full-time employees minus 30. So you can do the math. $167 is 1/12 of $2,000, and that's the way that it's going to be viewed. What'll happen on the penalties is you will have, as I mentioned before, when you report when you report the required information to the federal government, to the IRS, in March of 2015 or March of 2016, et cetera, here's what's supposed to happen. What's supposed to happen is the IRS is going to look at what the employer submits. It's going to then cross-reference that information with what your full-time employees submitted on their tax forms and determine if, oh yeah, there is Jane Smith over here, went to the exchange and she works for employer X, and Jane Smith received a subsidy, government assistance. Now we have to determine if the employer is failed to offer this to full-time employees as required by the Affordable Care Act. So you will not find out whether you're penalized until sometime in the calendar year following the end of your health insurance year, which for most people is on a calendar year basis.
And I have another question from Lynn McNabb. Is it okay to allow certain part-time employee groups to work more than 30 hours and not offer insurance as long as it falls within the 30% safe harbor?
The answer to that question is yes, it is okay, but only for 2015. So as I said before, you can screw up on 30% of your employees either by accident or on purpose and not get hit with a penalty for 2015, which, as I just mentioned, you would see if you're going to be penalized in 2016. The other thing that I will say is, and I'm going to talk about this in some detail in a couple minutes, is if you have determined that variable hour employees, I guess the question needs to be repeated.
Is it okay to allow certain part-time employee groups to work more than 30 hours and not offer insurance as long as it falls within the 30% safe harbor?
Okay, so if people didn't hear that, I will be happy to repeat it again. Sorry about that. The answer is yes. It is okay to basically say to no more than 30% of your part-time, any of your employees, but in this case, part-time employees, it's okay to say, all right, you're going to work more than 30 hours for some period in 2014, but we're not going to offer you benefits in 2015, health insurance benefits, that is, because we don't want to. I mean, you wouldn't say it that way, of course, but they'll fall within that safe harbor provision, and as a result, then you should not be penalized in 2016 for that failure to offer benefits in 2015. Keeping in mind that that 30% only safe harbor provision only applies in 2015, and 2016 it reduces to 5%. And so you can still use it the same way in 2016, you just don't have as much wiggle room to screw up. And there's actually another sort of trick, flaw, something, I don't know how to say it, but there's another sort of issue that I think you can take advantage of with regard to variable hour employees that we'll talk about when we talk about the measurement and stability period. So I'm going to go back now and talk, and we'll get to the slide on the second penalty here in a minute. But before we talk about what the second penalty is for employees or for employers, I want to make sure that we talk about the various components of what I mentioned earlier. That large employers, and you can see it there on your screen, have to offer adequate and affordable coverage. So what is adequate? Adequate is a harder answer to give to you because it's more of an actuarial determination. Basically, adequate coverage means that an employer is offering all of the essential health benefits either required by the state or the federal government if the state didn't set up their own exchange, and that the benefits are paid for at least 60% of the costs are paid for by the insurance coverage. That's according to the Department of Labor. 98% of all health plans provide adequate coverage, which is also discussed in some of the statutes and regs as minimum value coverage. And essentially, what that means is, in terms of the actual coverage, it means that the package has to include ambulatory patient services like doctor's visits, outpatient services, emergency services, hospitalization, maternity and newborn care, mental health and substance abuse services. And along that line, just keep in mind, one of the things the ACA did is it created some requirements for parity between mental health services and more physical health type services. You need prescription drug coverage of some level, rehabilitative and habilitative services and devices, lab services, preventative and wellness services, chronic disease management, and certain pediatric services, which include oral and vision coverage or care for pediatrics for kids. In Ohio, the other thing that was added is care for autism. So all plans in Ohio also need to provide coverage for certain autistic care that those diagnosed with that disease have to provide or are allowed to participate in. You can also go to the government website. It's cms.gov, and if you put into the search engine minimum value calculator, there is a calculator there. Again, I don't think most people on this conference call need to worry about that. Although I would strongly suggest that you get verification from your insurance provider or TPA if you're self-insured that their coverage in fact does meet the minimum value under the Affordable Care Act to provide you some defense down the road if that's challenged. The bigger issue for those large employers is under this second penalty is going to be the affordability component. What affordability means is that you need to offer health insurance. Went too far, sorry. All right, we're getting back to the right slide. There we go. So what this means is that you need to make sure that the health insurance that you offer as a large employer is affordable. Affordability refers to the employee's cost of health insurance premiums. It doesn't refer to how much the copays are or how much the deductible is or how much you do or don't contribute to a health savings account. It's only focused on the premium contributions. And what you have to do as a large employer is you must offer to all of your employees health insurance benefits that when you look at the single self-only premium, that was redundant, the single premium, that the lowest cost employer plan cannot exceed 9.5% of the employee's income. So you must offer, that doesn't mean the employee has to take it, but you must offer single coverage, and you can charge the employees a share of the premium, but that premium cannot exceed 9.5% of each of their individual income. Most employers are doing this, or many employers are doing this by offering the lowest level plan allowed for under the ACA. In other words, a bronze level type plan which has very high deductibles, only pays 60% of benefits, or of costs, I should say, and then that's the least expensive plan that's offered. Most employees, maybe even no employees, will sign up for that. That's okay, again, as long as it's offered, which is exactly the point of that plan. Analysis is true even if an employee takes family coverage. So I can have a wife and 2 kids on my policy. You require me to pay a premium contribution that exceeds 9.5% of my income. As long as I had the option of choosing that single-only plan that doesn't exceed 9.5% of my income, then you're all right. How do you determine the income is the next question. And again, please chime in if you have questions. But the next question is, how do you determine the employee's income? And the most likely way of employers doing that is to look at the appropriate W-2 wage box on the each employee's W-2. Now, I have to point out for you that there is an inconsistency here between the statute and the regulations. The statute says that you have to consider the employee's household income. I think those who were developing the regulations said, hey, that's a lot harder to figure out and for an employer to put their hands on than it is the W-2 wages that the employer is actually paying to the employee. So the regulations say you only can look at the employee's income with you, the large employer. That means you cannot take into consideration the employee's spouse's house income, which is part of the household income, any other income the employee has through investments, any income the employee might have through a second job even. I think that's going to be another area of litigation because obviously a household income many times is more than the income the employee receives from you as their employer. So if there's a 9.5% issue here, most employers I think are going to want to say, hey, wait a second, we need to look at the employer's the household income as opposed to just the employee's income. Like I said, I think we're going to see some litigation on that issue. So now what I want to do is we'll move to the screen that refers to the cost of the second penalty. The second penalty on paper might seem like it's more than the first penalty, but it's really not. Because in this situation, if an employer is offering minimum essential coverage, minimum value coverage, but it turns out for one or more employee that it's not affordable, and the employee goes to the exchange and they get a subsidy, the penalty that the employer will face is $3,000 per year or $250 a month per employee who falls into that category. So if you only have one employee who goes to the exchange because it's not affordable and gets a subsidy, then that's going to result in a $3,000 penalty for the employer. Never be not $3,000 per all of your employees, which is the first penalty. And it can never be greater than the first penalty, $2,000 per all of your employees minus 30. So this penalty won't be as costly to an employer, but again, it's certainly not something, it's going to add to your cost or potentially add to your cost for health insurance. So that affordability component is really important. What I want to talk about now is, and this gets a little technical, but I want to talk about now is the question of how you figure out who is a full-time employee for purposes of the Affordable Care Act. This is one of these areas where the criticism of lawmakers in Washington and Columbus make laws, so you need a bunch of lawyers to interpret them is an accurate criticism. First thing is, we talked about the 30-hour-a-week threshold. How do you determine hours of work for purposes of the Affordable Care Act? And as you can see from this slide, you have to consider vacation leave, holiday, sick leave, even duty, military leave, any leave of absence should be approved leave of absence, and even a disability leave. So it's a very liberal definition of hours worked. You can contrast that to the Family Medical Leave Act, under which you only require hours or record hours actually worked for determining those thresholds. So I'm not exactly sure how an employer is going to consider layoff, because if an employee is laid off and not paid, then they're not working at all. Does that mean that the employer still has to offer health insurance if they're laid off? I don't think so. I just think that component might have to be considered during the measurement period if you're looking at variable hour employees, perhaps. But that's going to be something that we need to tiptoe through and figure out how it might work. So under the Affordable Care Act, you're going to have basically three categories of employees. You're going to have those employees who clearly are working 30 hours or more a week who have to be offered health insurance. You're going to have employees who are clearly working less than 30 hours a week who do not have to be offered health insurance. And then you're going to have variable hour employees who you don't know if they're going to work an average of 30 hours or more a week. And let me repeat what I said before. You can reduce employees' work hours in order to avoid the 30-hour threshold, whether they're designed to be 30-hour-a-week employees or not. Now, again, for your public employers, there's some hoops you might have to jump through to do that, but for private employers, you don't even have to worry about that unless you have a union contract that governs something. Under the Affordable Care Act, there is a measurement period, there is an administrative period, and there is a stability period that has to be considered and applied in order to determine what variable hour employees are entitled to health insurance and which variable hour employees are not entitled to health insurance. So there are two components to the measurement period that we need to consider. There is a measurement period. Well, first of all, there's a monthly measurement period, or there's a look-back measurement period, which would apply to current employees. We'll talk about new hires in a minute. But for current employees, you can use a monthly measurement period, which basically you look at a month of service, you count an employee's hours for each month, and if they are working an average of 30 hours of service per week in that month that you're using, then they're entitled to health insurance coverage. I don't think that's the best way to look at it. It might be the most simple way to look at it, but it also gives the employer the least amount of flexibility in an effort to avoid perhaps having to cover some folks. And that's where the look-back measurement period comes in, which is the period, the measurement period for current employees. Again, we'll get to new employees in a second. But for current employees, right now you have to be deciding, do they qualify for 2015 coverage, or in 15, do they qualify for 16, et cetera, et cetera. And I know I've been making this presentation on the assumption that the employer, the hypothetical employer, has a calendar year-based health insurance year. That's not required under the Affordable Care Act. So for those of you who are not on a calendar year, these requirements will kick into gear at the beginning of your new insurance year in 2015. So if you're on a July 1st to June 30th, you don't have to worry about some of these things until July 1st as opposed to January 1st of 2015. So what the law allows is it allows an employer who has who is working variable hours, or you plan to have working variable hours if they're new, to have a measurement period that is anywhere from 3 to 12 months in length. You get to decide what that measurement period is. Now, you have to use the same measurement period for same categories of employees, but you can use different measurement periods for different employees based on legitimate factors. The law doesn't define what those legitimate factors are, but some of the considerations could be salary versus hourly employees, union versus non-union employees, or employees who work in different work locations. So, for example, for you counties who are, and I should have mentioned this, for purposes of counties, I believe the entire county, with some small exceptions, is considered the employer for purposes of the Affordable Care Act. So that means the county commissioners, who are the only entity, again with some small exceptions, who can buy health insurance, have to monitor what the engineer is doing and the sheriff is doing and all of the other separate elected officials. But for example, it might be that you want to, in a county setting or even in a city setting or private employer, you might have some employees who work a lot more hours in the summer or attached to some other season, and you may want to consider using a different measurement period for those groups of employees to try to get a result that has fewer employees who are hitting that 30-hour-a-week threshold through fewer variable hour employees. So what you do is you take a 3 to 12-month period and you literally measure at the end of that period how many hours the employee worked, the variable hour employees worked, and if they worked fewer than 30 hours a week, they're not entitled to health insurance coverage. If they work more than 30 hours a week, they are entitled to health insurance coverage at some point in the future. And again, I'm going to talk about what that means here in a minute. It all kind of fits together like a complicated puzzle. Let me first talk about new employees. So for new employees, what you're going to do, again, if they're clearly full-time or clearly part-time, you don't have to worry about them. If they're clearly seasonal, they're not entitled to health insurance coverage under the Affordable Care Act, even if they're going to work at least 30 hours a week. Seasonal, generally speaking, under the Affordable Care Act, is defined as 6 months or less, and usually associated with some seasonal type work, although you don't have to clearly fall within that kind of a definition. But if you hire people on to work full-time in the summer for a rec department or a pool or extra people on a work crew or whatever the extra people you hire on at the Christmas season, all of those folks would be considered seasonal and you don't even have to worry about them. But they're going to be variable hour and they're new non-seasonal employees, and you apply a measurement period to them as well, 3 to 12 months in length. Again, you get to decide. What happens then is at the end of the measurement period, anyone who qualifies, well, the end of the measurement period is an administrative period. The administrative period is defined as the period during which you're going to now allow the employee to sign up for health insurance if they're entitled to it. So the administrative period begins on the last day or after the last day of the measurement period, and it cannot be longer than 90 days. That 90-day threshold is consistent with the Affordable Care Act's requirement that a waiting period for getting on health insurance cannot be longer than 90 days. So those of you who have a waiting period of longer than 90 days, that has to change now. Frankly, it should have changed already because that requirement is in effect now. And that 90-day limitation applies to all employers, not just large employers. I know we probably only have large employers on this webinar, but I just want to emphasize that point in case you share this with information with anyone else. During that measurement period for new employees, then, they would have the ability to, I'm sorry, I misspoke. During the administrative period for new employees, they'd have the ability to then go ahead and sign up for health insurance coverage under whatever provisions, whatever requirements you have. For those current employees who are variable hour employees, you do not have to offer them health insurance. I'm sorry, I was going to misspeak about something. Let me move back on that. For those current employees who during the measurement period worked more than 30 hours on average, you now have to offer them health insurance benefits as well. And you have to offer them health insurance benefits even if during the administrative period they are now no longer working 30 hours a week because of what the measurement period told you. And then that takes us to the stability period. The stability period begins after the last day of the administrative period. And what the stability period is designed to do is it's designed to be stable for you as the employer and these variable hour employees. So during the stability period, variable hour employees who are found to have qualified for health insurance because meeting the 30-hour threshold during the measurement period have to be offered health insurance coverage for the entire stability period. Normally, this is going to mean for you, as a practical matter, this is going to mean for you the entire next the entire next health insurance year. So let me give you an example. In 2014, you have a measurement period of July 1st through September 30th. Through September 30th. So you have a 3-month measurement period. During that measurement period, you have some employees who are qualified under the ACA to get health insurance. Those individuals, once the September 30th rolls around, have to be allowed to sign up during the administrative period, which can be no longer than 90 days. Once they sign up, they are basically entitled to health insurance for the next year, essentially is how it works out as a practical matter. So now let me emphasize, there are nuances to this, and you're going to have to look at each one on a case-by-case basis, each situation. But what that means is that in my example, assuming you have a calendar year health insurance plan, that means for all of 2015, that person, in my example, is going to be entitled to health insurance, even if their hours drop below 30. Now, if they are no longer working with you, that's a different story, of course. But even if their hours on a regular basis are below 30, during the stability period, you have to keep stable, right, in my example, to have health insurance benefits. One of the potential problems with that goes back to this affordability question. So it's possible that you as an employer can end up with somebody that you're offering insurance to who is not working 30 hours a week, but 10 hours a week or 8 hours a week for whatever reason. You still have to offer insurance during the stability period, but now because of that person's much lower earnings, going from 30 to 8 or 10 hours in my example, that person might not, their premium contribution on the self-only premium might exceed 9.5% of their income. So that's another reason why it's important to offer, if possible, that extremely lowest level plan that meets minimum requirements, even if no one takes it, because you might have those kind of people who fall into that situation. This is where I need to take a deep breath, and because we have talked a lot about technical stuff, but I need to go back and talk about with you what happens to those employees who during the measurement period did not meet the 30-hour-a-week threshold. So they're not entitled to benefits. Their administrative period is nothing but something on paper, and they get a stability period as well. And during that stability period, you are not required to offer them health insurance coverage, even if they're actually working 30 hours a week, because the stability says if they're still variable hour employees. Now, if you reassign them to working 30 hours a week all the time, no matter what, then you're going to have to offer them health insurance. But if they average more than 30 hours a week during the stability period and they're still variable hour employees, you probably will not have to offer them health insurance coverage. Also, this goes back to the comments I was making earlier about you're allowed to reduce employees' hours below 30 to get out of an obligation to cover them. The opposite is true as well. So if you have with variable hour employees only, if you have a variable hour employee who during the measurement period does not qualify for insurance because he or she is working fewer than 30 hours a week on average, then they don't get insurance for the entire time during the administrative period and for the entire time of their stability period, which means that on a sporadic, on an irregular basis, or to use the word of the statute, a variable basis, you should be allowed to work them in excess of 30 hours and not have to worry about giving them health insurance. I'm not suggesting you should do this on a regular basis and with everyone and as a plan, but let me give you a for example. I got a question from a client. It's a fire department, and they have part-time employees. They put them through the measurement period's over. They worked an average of 24 hours a week. They made sure that it stayed that way. But now they're shorthanded because of the summertime with vacations and whatnot and filling vacancies. So their question was, can we work them 30 hours, again, not on a regular basis, but even if it averages more than 30 between now and October, the vacation season, will they be entitled to insurance? And the answer is almost for sure no, because they're now in their administrative period and their stability period. So that's kind of a lot to throw at you, and kind of, at least from my perspective, harder on a webinar where I'm not seeing your faces and your puzzled looks and able to ask you to come forward with questions you may be reluctant to ask. But again, I'm just emphasizing it. Please, go ahead and throw them at me if you have these questions. Also, you have my contact information, so feel free as a follow-up, if you have follow-up questions after this webinar is over, to shoot me an email or whatever, or even if a phone call if we need to, just to understand the nuances of any questions you might have. One thing I want to touch upon for public employers is this idea of volunteers. I should say public employers or 501c3 organizations, nonprofits. One of the things that the regulations did was give us some relief of what the statute was originally going to do with regard to the status of volunteers. So specifically, a bona fide volunteer, even if they get some stipends or reimbursement, are still exempt from the statute. All right, we have a couple questions, so I'm going to go back to them, and I just accidentally changed my PowerPoint instead. Go ahead, you want to.
If we choose a 6-month measurement period, how would the timeline look for a calendar year plan? Okay,
so question, I'm just going to repeat it since I'm closer to the mic. If we choose a 6-month measurement period, how would the timeline look for a calendar year plan? Well, you can choose any 6 months. Let's assume you're covered in 2015, that the law applies to you. So you can choose any 6 months in 2014 to measure the variable hour employees' work hours. Of course, as we're sitting here right now, if that hasn't been done already, you got to do it prospectively only. So you've got July 1st through December 31st. You absolutely can do that under the law. The problem with that is, though, that if you choose to go to the end of the year and December 31st and you're on a calendar year plan, then you're going to have an open enrollment period or administrative period that overlaps with your calendar, your actual plan year. So if you haven't done a 6-month calendar year already, then I would suggest you doing something less than 6 months so you can end by November 30th and have December 2014 being the open enrollment period / administrative period. We have another question. Is there a remeasurement period after the stability period for subsequent years, or do you only measure once and it holds for them after? That's a good question. There is a remeasurement period. You have to do it on an annual basis. So that means that if you have a measurement period this year and you have some variable hour employees who are subject to coverage and some who are not, next year you have to look at your variable hour employees again, and they might be different people or different positions, and apply a measurement period to them next year as well. So you have to have a measurement period every year in advance of your coverage, whatever that might mean. Okay, got another question here. We were told that city council members must be included in the count to determine how many full-time equivalent employees we have. Our council meets twice a month. Are they eligible for health insurance? Well, there's two different questions that you asked there. First of all, do you have to count city council members as full-time equivalent employees? The answer is yes, because first of all, there's no exemptions for elected officials under the Affordable Care Act. However, if those city council members or any other elected official works fewer than 30 hours a week, then you just have to figure that in to the whole component, the whole mathematical equation of, all right, how many hours divided by how many employees? Now tell us how many full-time equivalents we have to see if we meet the 50-employee threshold to be a large employer. If you meet the 50-hour threshold and your council members do not work regularly on a regular basis 30 hours a week or more, then they are not entitled to health insurance under the Affordable Care Act. Now, you can still give them health insurance, but they're not entitled to that under the Affordable Care Act. So the answer is yes to the first part, no to the second part. Got another question here. Do you need to inform employees of what measurement period you selected? I think the answer is yes. I think the answer is yes. I don't believe the law specifically addresses this, but you don't want any confusion. And frankly, local government entities, and this person who's asking is from a city, those things need to be addressed probably by legislative enactment. So city council or county commissioners should be passing a resolution setting that period. If you didn't and you go, by all means, go for it, and don't worry about it at this point and catch up later. Next question. Under the 6-month measurement period scenario, could the measurement period be from January 1st to June 30th, with the administrative period being the last 90 days of the year and the stability period beginning 1/1/15? Well, the honest answer is I'm not sure, and I'm going to have to give some thought to that. And again, I know who's asking, so I will try my best to answer it right now, but I will also follow up with the questioner on this to see if I can get a better answer, and try to post something so folks who are participating can get a better answer as well. Because here's my concern. Here's why I hesitate and sigh. Because it makes sense that you should be able to do this. So your measurement period would be 1/1 to 6/30, a 90-day administrative period, and then the stability period beginning 1/1/15. The problem with that scenario is that according to the law, the administrative period has to start right after the end of the measurement period, which this example it does, and then the stability period has to start the last day after the administrative period. And I'm concerned that in this situation, the administrative period would start, the stability period would start September 1st and then have basically a stability period that lasts 15 months. So from September 1st, 2014 to December 31st, 2015. That does not strike me as acceptable under the law, but I can't give you chapter and verse why, and I apologize for that. I think I'm just being honest here because there are a lot of confusing issues still lurking out there. So I will follow up with the questioner, and I will also make sure that we have something either goes out to all the participants via email or something on our website that answers this question more definitively in the next couple of days. I appreciate the questions. Okay, so now, and again, please feel free to come back to this stuff, but I'm going to move away from the stability period and measurement period and all those other kinds of things. Oh, I'm sorry, of course, as a lawyer, I just lied when I'm speaking, as they say, how do you know when a lawyer lies? So I do want to talk about one other subject related to the measurement, stability, and administrative periods, and that is reinstatement of former employees. If a former employee is reinstated or rehired, they can be retreated as new hires for purposes of measurement period, administrative period, and stability period if they have been gone from your employment for at least 13 consecutive weeks, or if the break in service is less than 13 weeks, and if the break in service is less than 13 weeks, the employer can still treat the individual as a new employee if the break in service is at least 4 weeks and is no longer than the preceding period of employment. So there are scenarios under which, and actually the original regulations you may have seen said it had to be a 26-week break in service. Now it's 13-week break in service. All right. As I mentioned before, the reporting requirements have been delayed. If you go to the IRS website, you can see the information that you're going to have to report. I'm not going to get into a lot of detail about that. Suffice it to say that, especially the first time around, it's going to require the employers to spend some time doing that. And also, your plan has reporting requirements as well. You want to make sure that there's not inconsistencies in any of those reporting requirements. Now I'm going to talk about wellness programs for a couple minutes. There are new rules for wellness programs that are in conjunction with the Affordable Care Act. The idea behind these rules is to encourage wellness. The problem with that, at least as I see it, is that for clients that we represent who do wellness stuff already, it's going to become a little more technical and maybe a little more difficult, and you're going to have your hands tied a little bit more. You're going to have to make that judgment for yourself. But first of all, let me make this clear from the get-go. A wellness program that does not offer an employee a break on a monetary award, whether that's a break on their premium coverage or more money in your HSA or a gift card to Starbucks. It doesn't offer any of that stuff, and it's just designed to voluntary, if employees want to participate and maybe get them thinking a little bit about some of these issues, then these rules do not apply. You can do whatever you want, basically. I mean, there's some certain ADA issues and HIPAA issues and genetic information, Non-Discrimination Act issues, potentially, but you can have a program that says, all right, at lunch today we're going to have a nutritionist come in, or fill in the blank, and if you want to come, great, and if you don't want to come, that's up to you. On the other hand, if you want to give employees a benefit, which is, not uncommon, then you have to first of all consider the two categories that the ACA sets forth in the regulations for wellness programs. There are participatory wellness programs and there are health contingent wellness programs. Participatory wellness programs, and there's really a fine line between these things. So participatory wellness programs are programs where there is a reward, but none of the conditions for obtaining the reward are based on an individual satisfying a standard relating to a health factor. What that means is that, in my example I gave a minute ago, if you have an employee who's sitting, or employees who are offered the ability to come to a lunch program about good mental health, stress relief, eating right, exercising, but just sit there and listen, then that's a participatory wellness program. This participatory wellness program, if you decide to do it, has to be made available to all similarly situated individuals regardless of their health status. So you can't make any distinction based on, well, you're in good shape and you don't really need to have this this class on nutrition, so we don't want to bother wasting our time with you and give you a bonus. I mean, I don't think anybody would do that, but that's the only example I can think of how somebody would differentiate between healthy, health status. So that's participatory wellness programs. Then you have health contingent wellness programs, which is a wellness program that requires an individual to satisfy a standard related to a health factor to obtain a reward. So there are two types of contingent wellness programs. I avoid tax law because it's so complicated and I can't understand it. But then I have to deal with this kind of stuff. As long as you don't attach numbers to it, I'm okay. So you have activity-only health contingent wellness programs, which sounds a lot like participatory wellness programs, but it requires the individual to actually perform or complete an activity in order to obtain the reward, but doesn't require that person to attain or maintain a specific outcome. So an example might be if you walk or take a certain number of steps, and we're going to give you a pedometer, or you can use your iPhone or your smartphone or whatever. If you take a certain number of steps a week, or you walk a certain number of miles a week, then that's going to be an activity-only health contingent wellness program. We don't care if you do it all in one day or you do it in a 4-minute mile or a 30-minute mile, as long as you do it. So that's the distinction, that you're actually doing something as opposed to just sitting there listening to some type of program. And the other health contingent wellness program is an outcome-based program, which requires an individual to attain or maintain a specific health outcome, such as not smoking or attaining certain biometric screenings. And those are contingencies of obtaining the reward. Now, you also have to be careful with ADA-related issues, or I shouldn't say ADA because it's disability-related issues. So health contingent wellness programs require you to provide eligible employees with the chance to qualify for the reward at least once per year. It also, as I mentioned before, has to be available to all similarly situated employees, which means that, according to the ACA, employers have to have available a reasonable alternative standard or a waiver, an outright waiver of that requirement, to be available for those employees who cannot perform due to a medical condition or for whom a medical condition makes it inadvisable for them to take part. So that would apply to any health contingent wellness program, whether it's activity only or outcome based. That said, What you do not have to have, or you do not have to and should not try to determine in advance what that alternative might be. But you do need to have a written policy if you want to have these wellness programs that says to employees, we will provide you a reasonable alternative standard if you can't participate due to a medical condition, or if a medical condition makes it inadvisable for you to take part. So an example that comes to mind is a person in a wheelchair is not going to be able to take a certain number of steps a week. You have to have an alternative for that person if they come forward, and of course they will. You should probably approach that kind of a person where it's obvious that they can't do it and ask them if they want a reasonable alternative, or again, up to you, you could also waive it completely and give them the reward. Just like the ADA, you have to take into consideration all facts and circumstances of what a reasonable alternative standard is. If the individual's doctor states that a plan is not medically appropriate for the individual, that's when you have to provide that reasonable alternative standards. You can impose a standard cost sharing under the plan for medical items or services that are furnished to that individual to participate in the wellness program to the individual based on the physician's recommendation. What makes no sense to me, however, is for activity-only health contingent wellness programs, you can require verification about what the validity of what the doctor is saying or what the employee is saying their doctor is saying. For some reason that I do not understand, the regulations prohibit the employer from seeking verification of the validity of the request if it's an outcome-based health contingent wellness program. I do not have a clue why that makes sense. Maybe somebody smarter than me can explain that logic, if there is any. Finally, on the wellness program issue, keep in mind that you can only, and this is where some of the changes might affect some of you, another area where changes might affect some of you who are already doing this, but the reward cannot exceed 30% of the total cost of the employee-only coverage, even if the employee is taking family coverage, or 50% of that coverage if the wellness is specifically designed to prevent or reduce tobacco use. So there are limits on what you can actually provide to the employee as a reward economically, whether that's here's cash or here's a reduction of your premium. That's up to you to decide. There are two other things I want to talk about. One I just thought of, and then we're going to talk a little bit about the Cadillac plan, and then again I'll give folks a chance at the end to ask questions. Talking about the tobacco use just made me think of one other point I wanted to make about the exchanges. Under the exchanges, well, not under the exchanges, there are, and this is true, I believe, also of any employer-offered plan. There are only 3 factors that that can be considered in determining how much somebody pays for health insurance. Currently, there are a lot of places, usually smaller employers, but not exclusively, where employees who want to participate in insurance have to fill out a form that says, here's my health history, basically, and here's my family's health history if you want family coverage. Now the only things that can be taken into consideration is age. Age can be a factor in determining how much a premium will cost. Where you live can be taken into consideration. Actuarially, if that's a word, it must be that determined that if you live in certain areas, you're on average expected to be more healthy than other areas. So the insurance providers can charge based on that. And finally, you can take into consideration tobacco use or whether or not they use tobacco. So the one thing that you absolutely cannot do anymore, for example, is the woman of childbearing years. I don't think there can be a difference between a 28-year-old woman and a 28-year-old man. There can't be. We just got a question. After the webinar is complete, could we receive slide copies via email, and better yet, a copy of a more detailed print handout like what you provided at in-person training sessions? The answer is absolutely yes. We will email you both the slides and the outline that I've been referring to that has a lot more detail than the slides. So we'll make sure we get that taken care of. Last thing is this Cadillac tax I want to talk about. The Cadillac tax is something that is not supposed to go into effect until 2018. And frankly, when I first saw this, I'm thinking, oh, big deal. This is going to be for those employers who still give those really fancy, crazy level of benefits. Its design or purpose, I believe, is to reduce the cost of health insurance by taking away some benefits that are really out there and drive up the cost. However, from what I've been hearing from clients and employers in general, it is possible, more likely than I thought at least, that by 2018, the Cadillac tax will affect many more employers than first thought, or than at least I first thought. This is one of these 2018 deals where, okay, it's intended to go into effect in January 1st, 2018, but we don't have any regs yet. It could be moved back. I don't know. The tax is 40% of the amount of the premium, and when we say premium, we mean the total premium. It doesn't have anything to do with how much the employer or the employee pays. So 40% of the total premium on an annual basis that exceeds $10,200 for single coverage or $27,500 for family coverage. I would strongly recommend that you do a couple of things at this point to start planning for it. First of all, talk to your TPA or your consultant or whoever you deal with on insurance and get an idea of what the numbers are looking like for 15, 16, and 17. I know that's a guess at best to see how close you might be coming to these figures. There is this website on your screen is a place you can go that has a calculator. I have not used it. I'm assuming it just asks you to plug in your estimator, or maybe they estimate for you health insurance premium expected increases. After 2018, this number increases by the amount of inflation, the CPI, not by the amount of the inflation associated with health insurance, which we all know is much greater than CPI. Now, maybe there'll be some relief in the regs on that. I don't know. None of us really do know. The other thing, for those of you with collective bargaining agreements, it is crucial now, or when your new contract is up, to start planning for these changes, because if you're obligated to continue providing a level of benefits that's currently set forth in the contract, in your collective bargaining agreement, regardless of cost, you're going to be hit with this penalty, and you can't do anything about it except pay it. So that's really an important consideration right now, and I think logically something that would give you a good, some good leverage in negotiations. There are a lot of ways you can approach that, but I think it's time to have a frank conversation with that. Now, a couple other quick points, and then I'm going to stop. When you're dealing with the Cadillac plan, we're talking about premium for health and prescription drug insurance only. Dental and vision plans are not included if they're standalone plans. If they're plans that are part of your regular health and prescription insurance coverage, then that cost counts as well. So you may want to separate those out if you are in that situation. It also takes into consideration employer reimbursements under a flexible spending account, health reimbursement plan, or health savings account. So the amount that you put into those things or pay for employees over and above your health insurance premiums also will be taken into consideration in seeing if you reach that threshold. Again, it's the amount the employer is paying, not necessarily the amount the employee decides to put into his or her health savings account out of their own pocket. The tax is supposed to be paid by the entity providing the coverage, So for fully insured plans, it's the insurance company, and self-insurance plans, it's a third-party administrator. But we all know that it's going to be done to healthcare customers, the consumers, which means you as employers and then your employees. So that might be another factor when you look at the idea of going to letting your employees go to the exchanges down the road. I'm not sure. So having said that, I am finished. I really appreciate your participation. I would very much appreciate everyone's feedback, whether now or down the road, whether it's good or bad or suggestions for improvement. Frankly, this is the first webinar our firm has done as a firm, and we hope to do more. Finally, if anybody has any questions, it takes you a couple minutes to maybe put them in, so I'll sit here in silence for a couple minutes if you want to put in. You're welcome. I got a thanks mark, so I'll take that as a positive feedback. The news is none of you I will be happy to send you all that information that was asked for, and none of it will be accompanied by a bill. So I know